How can a motion for attorney's fees on behalf of a client lead to a public boycott of that client? In this video, I'll tell you. Hi everyone, my name is Pollock. I am an attorney who helps other attorneys and their clients ethically, strategically, and proactively engage the court of public opinion. In this video, recorded in the sweltering California sun, how normal and typical court filings in a court of law can wreak havoc on a client in the court of public opinion. One of the core pieces of advice I give to attorneys and their clients when they are contemplating engaging the court of public opinion, or they're already sucked into a high-profile case and they have to fight back, is that they need to be cognizant of how what they do in a court of law will be interpreted in the court of public opinion. And I just read a recent article about some issues that a theater company in the Midwest is facing that really hammers home this point. So there is a children's theater company in a large Midwestern city that's going through its own sex abuse scandal. And there are currently 16 or so plaintiffs who have filed lawsuits against the theater company alleging that it was negligent in not preventing sexual abuse that happened at the theater by instructors or other of the theater's representatives in the 1970s and 80s. One plaintiff recently had a trial and was awarded $3+ million by a jury, a state jury, regarding her claims against an individual who was a former instructor at this theater company and the theater company. Now, the damages were levied against the instructor. The damages were not levied against the theater company, although the theater company was found by the jury to be liable. That's important here. Soon after the trial and the verdict, the theater's attorneys filed a motion for attorney's fees against the victim here, the plaintiff, who is a victim of rape. And the attorney's fees motion alleges that because the theater was the prevailing party in the case, because there were no damages levied against it, the plaintiff, again a rape survivor, should be liable for attorney's fees, upwards of I think about $280K. Well, attorney's fees petitions are common in a court of law, but you could imagine what the public response was after this motion was filed. It got bad publicity for the theater company. The theater company was forced to issue a video apology that said that they underestimated the impact or how the motion would be interpreted by the public. They were sorry, and that they were not going to pursue, or at least they suggested they weren't going to continue pursuing this motion or file any other similar motions down the road. Now, the theater company issued this public apology, but not before the plaintiff against who the fees motion was filed called for a boycott of the theater company, and some of her supporters and fellow plaintiffs in these litigations against the theater company joined in for the boycott. So this is a prime example how what happens in a court of law has an impact on the court of public opinion. And I'm not here to cast any blame here. I don't know if the client, the theater company, or the attorneys, I don't know exactly how this decision was made. I don't know who made it. I don't know the strength of the law. All I know is after this petition was filed, the theater company had to issue a public apology. The theater company is taking a beating in the local press, is taking a beating in terms of its business, and you've got serious damage to a client here. But there's also potential for serious damage to the attorney. Do we think that this cinema company will refer their attorney to a prospective client knowing that the attorney was involved in this kind of issue? I don't know. I don't know if the legal community will look differently at this attorney for being involved in this fee filing as well. There are a number of other examples of this where what happens in a court of law, even though it might seem pretty mundane, outrages the court of public opinion. I can think of when you have some high-profile negligence cases and defendants will move as part of their, or insert in part of their answer affirmative defenses, and they'll include an affirmative defense of comparative negligence, and the public and the media gets up in arms because it appears to be victim blaming and blame shifting onto the victim. Now, that type of thing, we know as attorneys, you have to make those affirmative defenses or you might lose them, but the public doesn't understand that, and the media doesn't always understand that, especially when you've got some kind of sex abuse case or some kind of salacious case where the affirmative defenses appear to be casting blame on the alleged victim. So my guidance to attorneys and clients when they're faced with these kinds of filings or legal strategies that seem ordinary and mundane in the court of law, but could be a problem in the court of public opinion, is to take a step back and think carefully about what the blowback could be like. Is there blowback possible? Take the worst case scenario, take the viewpoint of your worst critic, and determine, is there a possibility that we could get hammered here for making this claim, for filing this paper, for taking this legal strategy? And if so, is there a way that we can get around it and we can frame this ahead of time in a public statement that allows us to still do what we have to do in a court of law, but not outrage the court of public opinion? Obviously, attorneys have to be careful not to let the tail wag the dog. They don't want to do everything in a court of law or nothing in a court of law because of what they perceive the reception by the court of public opinion to be. But at the same time, attorneys have to be cognizant of what the court of public opinion might have to say about some kind of legal filing or some kind of legal strategy. If not, the attorneys and their clients will end up like this particular this particular theater company in the Midwest, and be the object of boycotts, of protests, and could see both the client's reputation and the client's prosperity go down the drain.